Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right, folks. We're back. We're back with the Truth Attack. Okay, so there's a lot of material we want to get through tonight, so let's just get right into this. We are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the network operating. So, if you enjoy the shows, the information, the lectures, the discussions, the revelations, the guests and the hosts on the other shows on the network, we sure would appreciate it if you could find your way over to the libertyworksradionetwork.com website, get signed up as a monthly subscribing member, even if it's as little as $10, $15, $20 a month. Every membership counts, and we do need your support to keep the broadcast network operating. So, tell your friends, family, neighbors, business associates to join the Liberty March. Get informed, get educated, find out what's really happening, get the news from the sources that the government doesn't want you to know about, and the information they don't want you to have, because what the mainstream media is telling you is just absolute garbage. It has been for what, about 10 years? Yeah, that's about right. 10 years of absolute garbage, which of course is what the public schools are teaching the kids, which is why nobody can answer simple questions like 5 times 7. Okay, so we're getting a little off track. All right, we are the Liberty Works Radio Network. Get tuned in, get informed, get educated. And if you want to get fully informed on my favorite topic on the show, which is the maladministration of the federal personal income tax by the IRS, the Department of Justice, and the lower federal courts for the last 75 years, which the Supreme Court has put an end to with their most recent rulings on income tax and taxation in general, handed down in 2024 in Moore et Ox v. United States. And if you want to get educated on that, head over to taxfreedom.com and start reading. I got it all written up, what's going on. And if you know anyone that needs help answering the IRS administrative correspondence or answering the DOJ in court, send them over to irszoom.com, where you can get affordable help answering the IRS and answering the Department of Justice in court with the challenges they don't want to address because they can't. Okay, so of course, the news today, a whole week since Saturday morning, has been Trump's finally stepping up and ending the 47-year-long war that Iran declared in 1979 and has been waging through terrorist proxies against the West and the United States since 1980. 47 years of war, terrorism through Hezbollah in Yemen, Hamas in Gaza, the Houthis in Yemen, all sponsored and paid for by the radical Islamic regime in Iran, which has been waging war on the world, pushing terrorism. You want peace and prosperity? Kill the terrorists. Stop the Iranian oil money from funding terrorism all over the planet. The Iranian people don't even support the Islamic regime that is in the process of falling, which was already in the process of falling through the civilian uprising that's occurring and not being publicized by the media, but which should be fatal to the Islamic regime, given that Trump in the U.S. has basically taken out the entire Iranian military structure. The only thing they have left are feet on the ground, which are opposed by the civilian population. So, in 24 hours, well, I guess 72 hours, the Epic Fury, it's the name of the operation the U.S. has put, has completely destroyed and eliminated from existence the Iranian Navy. Gone. No boats left. Gone. The Iranian Air Force. Gone. No planes left. The air defense networks, gone, completely eliminated. The missile launch pads are almost all gone and will be shortly. Every time they launch a missile, the defense of the U.S. responds and wipes out the facility. They wiped out the entire leadership council, military, government, and religious. Over 49, 50 leaders in the first 3 days wiped out the entire political, religious, and military leadership of Iran. They have been decimated, and it's about time. Because without the Iranian oil money to fund the terrorists, Houthis in Yemen, they can't interfere with oil flow through the Red Sea. And without Hamas in Gaza, we can finally get something settled there. If you can get the Palestinians to accept any sort of a two-state solution, which so far they have absolutely rejected. But now, hopefully, with Hamas being castrated and losing its funding and support from Iran, perhaps that can be actually reconstructed, which is what Trump and the West are planning to try and do if they can get any kind of civilian order there. So, Iran has been the terrorist play for 47 years. They declared war on America. And Donald Trump is the only president who hasn't chosen to ignore the fact that they're actively waging war on America without actually attacking everything American, just interfering with Western business and creating violence and terrorism in the Middle East. They using the bunker busters to hit missile launchers buried deep in the earth. They've wiped out drone production facilities. As I said, they've wiped out the entire government, military, and religious command structures and the radical religious leadership that's been sponsoring terrorism all over the planet. So, a lot of people don't like it. A lot of people think that's illegal and that he shouldn't have done it. But under the War Powers Act, he gets a certain amount of power to respond and to prevent and to protect. We'll see how long it goes on. Hopefully, this will be over within a month or two, and civilian leadership will step up in Iran, which is kind of the gamble they're taking. Is that with the religious radical leadership wiped out and the military command wiped out, maybe what's left will get together to decide they want a more civilian government operation, not based in 6th century Sharia misogyny and violence and slavery, rape. I mean, it's just absolutely insane what this religion, so-called religion, I don't think it's a religion, I think it's a cult, but absolutely insane what this religion claims to be based on. Absolutely insane. Not one bit of it represents God. Not one bit. It's more closely related to satanic operation than anything under God. Oh, and so what was Iran's response? Oh, naturally, they attacked all their neighbors. All their neighbors. You would, of course, expect them to attack Israel, who was participating with the strike and is actually the group that went after the leadership. The U.S. is addressing the defense and military structures and facilities. It's Israel that went after the command. Iran, of course, attacked Israel with missiles, and they also attacked, just randomly, launching missiles at the UAE, Bahrain, Saudi Arabia, Kuwait, Qatar, Oman, Iraq, and Jordan. Iran has attacked all of the Arab nations around it. Not just Israel that attacked it, but all of the Arab nations around it, none of which participated in the attack or had any knowledge of it. So who knows what Iran is thinking? Oh, you guys should have helped us, so we're going to attack you. Excuse me? It was over before we knew what was happening. So you can see the command structure in Iran is reacting intelligently again. waging war on the entire planet. Oh, that's not going to go well for them, and hopefully, as I said, one of the gambles here is that the civilian Iran will step up and create some kind of quasi government structure operation facility that US and Trump can work with to develop to help them take back the oil resources. And of course, it looks like the bet that Trump is making here and the timing on this is that even though this has the possibility to disrupt oil flows in the Middle East by taking the Iranian oil offline for a while, the Venezuelan oil coming to America now has the ability to offset in the world supply the loss or disruption coming out of Iran, so that there won't be a huge disruption to oil. Now, the markets are all reacting to the war and the price of oil has spiked, but that's a natural reaction, and how things go over the next 20 days will determine whether the price stays high or comes back down again. But, if the civilian Iranians, which were already acting and asking for help, well, they've gotten the help. Now they need to finish the job, step up and create some kind of civilian operation that isn't anti-West and wants to salvage what can be salvaged out of the Iranian system there, and probably get help rebuilding too if they can get the Islamics out of power. So what you're looking for is regime change without destruction of the oil assets. And that will prevent any real world economic shock and will enable the new Iranian government to recover quickly, because the oil revenues can be directed to the Iranian people's rebuilding and restructuring rather than being spent on sponsoring terrorism all over the planet. So the gamble here is to take out the regime, put in or allow to assume a civilian command that is willing to deal with America and not wage war on the planet without destroying the oil facilities, so that the new government can have revenues to continue to operate. And I think that all of the military strikes have been carefully arranged around that master plan to take out all the defense abilities, all the offensive capabilities, to wipe out the leadership of the terrorist organizations and preserve the economic assets that are critical to Iran and ultimately the world economy, where the shock, just like taking out Venezuela, was a shock, has been and is a shock to the Cuban energy system, which is now having blackouts, is going to have to come to the table or get displaced as a government. The shock is that the Iranian disruption is going to affect only Russia and China, who are pretty much the only people getting oil from Iran, maybe India too. But hey, if there's an oil shock to Russia and China, good luck to them, right? Just like good luck to Cuba. So that's the way that's laying out. And so far, it's been a pretty effective plan. Just like in Venezuela, the U.S. military Iran never had a chance militarily. They virtually wiped them out. Like I say, no Navy, no Air Force, no air defense systems. Everything is pretty much being remade in Iran. We'll see how it comes out of it. The media and the Democrats, of course, are just all freaking out. Well, of course, they supported Khomeini for 40 years, didn't they? And Hamas and Hezbollah and the Houthis and the criminal illegal aliens and the open borders and no deportation, and they want alien voters, foreign voters, keeping them in power, giving representation to foreigners in the United States government. Democrats are anti-America. They're what? Pro-terrorism? Because that's what they're supporting. They're supporting criminal aliens. They're supporting or opposing taking out Iran. They oppose taking out Maduro. These are criminal dictators being taken down, and the Democrats are pissed. Okay, this is Thomas Fried on the Liberty Works Radio Network, and I just got one last thing to say about this in Iran, and that is with the buildup of military armament in the Middle East area that's been occurring and publicized for the last 30 days. No one should have been really surprised that this has occurred. Trump told them for over a year, come to the table, negotiate, there's going to be trouble. The military, he built it up, he told them, come to the table and deal, there's going to be trouble. They played their same games, so now they got trouble. Okay, so let's move on, right? Last couple of weeks I've been reading from the brief to the Supreme Court, which we're asking to end socialism in the United States, because of course income tax, graduated income tax, is communism. It's the second plank of the Communist Manifesto. That's socialism. And enslaving the people to pay for the government, that's socialism. And the government taking ownership and controlling all of the operations in education, agriculture, energy, housing, transportation, commerce, environment, occupational safety, etc., etc., etc. That's socialism. It's not capitalism. Capitalism doesn't have a Federal Reserve Bank with a monopoly on currency and credit. Capitalism doesn't have the direct taxation and enslavement of the American people. So what we've been practicing since the end of World War II is a quasi-capitalism at best, because it has all the elements of socialism. And as I've spoken about many times before, it's the income tax that is the heart of the ability of the government to push and enforce socialism, because it's the graduated brackets that create the class divide that results in the class warfare that ends up with both classes constantly calling for the government to assume more power, to end the class warfare and class conflicts occurring in the streets that the government engineered in order to usurp more power. And it's an endless cycle of ever-growing violence and more government power till tyranny is confronted with violent revolution. It's an obvious cycle. So while Trump is ending terrorism, we're asking the Supreme Court to end socialism. And let's jump out and review this. You know, we're up to issue 8, but let's go back and review the first 7 issues that we've been reading from for the first 2 weeks so that we get everything covered. What do we want to do here? I need to switch to the image sharing view. Okay, here we go. The 7 issues that we've already looked at and addressed. And you can find this on the Supreme Court now. I should have the number, but I don't. It's been docketed. It's Cromar v. United States. So the first issues were, in Moore et Ux v. United States, the Supreme Court held that the federal personal income tax is an indirect tax under authority of Article 1, Section 8, Clause 1 of the Constitution. Now that right there is trouble, because for 45 years, the circuit courts have been telling us it's a direct tax under the 16th Amendment. Supreme Court says, no, that's a lie. It's an indirect tax under Article 1. Issue 2, the Moore Court held that all direct taxes must be apportioned to the several states for payment in proportion to the last census as required under the Constitution by Article 1, Section 2, Clause 3, and Article 1, Section 9, Clause 4. Now that's a problem too, because for the last 45 years, the circuit courts have been telling you the 16th Amendment did away with this requirement. The 16th Amendment replaced these 2 provisions. They no longer exist because it's a direct non-apportioned tax on everything you do. And the Supreme Court here says, in Moore, no, that's wrong too. All direct taxes must be paid by the state. Federal government's prohibited from showing up on your doorstep demanding that you pay a direct tax of any sort, including one on all your earnings by right, redefined improperly by statute as taxable income, when they're not. Number 3, the federal personal income tax is not a non-apportioned direct tax on income under the 16th Amendment. That pretty much kills what they've been doing for 50 years. It's over. 4, the case record shows the district court erroneously claimed a subject matter jurisdiction under the 16th Amendment to enforce a non-apportioned direct tax on income against the individual defendant. So they absolutely did what the Supreme Court says you absolutely cannot do. And the record shows that clearly. Issue 5, under the Constitution and more, the federal courts lack the subject matter jurisdiction to conduct tax trials of individuals, both civil and criminal, to enforce against them the payment of a non-apportioned direct tax on their own income under an alleged authority of the 16th Amendment to tax directly and without limitation. It's all a lie. Was never allowed. It's all unconstitutional. And this brief lays it out for you. 1, 2, 3, 4, 5. Issue 6. The circuit court erred in its judgment by stating, since ratification of the 16th Amendment, whether an income tax is a direct tax and an indirect tax is immaterial. Well, that's nonsense. Direct taxes have to be paid by the state. That's certainly relevant. If it's direct, it can't be on you. It further erred in asserting that it is beyond dispute that Congress has the power to tax the income of individuals, as Article 1, Section 8, Clause 1 does not authorize any such direct and unavoidable taxation of the citizens of the 50 states. So it's erroneous to say that Congress has the power to tax the income, because that claim is based on the fraudulent assertion that there's a direct non-apportioned tax. As soon as that direct non-apportioned tax goes away, there's no basis in Article 1, Section 8 to tax the labor of American citizens. It's a fraud, and it doesn't exist. Issue 7, no admissible prima facie evidence of tax under IRC Section 6201, 6020B, and 6020B2 that was good and sufficient in court for all legal purposes was presented at trial sufficient to support a conviction of the defendant under 7201, which requires a subscribed tax return. But this guy was a non-filer. The government just made it up with a computer printout. There is no subscribed tax return anywhere to create a formal assessment of tax owed. They lied. They made it up. They never produced any assessment at trial. Okay, which takes us to where we are today, Issue 8, which reads, the Chevron doctrine of regulatory deference has been overturned by Loper-Bright, which means a liability for tax cannot be determined and tax assessments cannot be made using only regulations that operate outside of and beyond the actual authorities specified in the underlying controlling statutes of Section 1 and 6020B2. Now, this is how the government conducts all of its tax trials, both civil and criminal. They produce no evidence of an assessment. It's all made up by computer printouts that are not a subscribed tax return, which is the only evidence allowed by statute that's prima facie good and sufficient. Nothing else meets that statutory standard for evidence in the case. They've just made it up with regulations. The plaintiff admitted at trial that they only proved that money was earned by the defendant from within America and did not show by prima facie best evidence under Section 6020B2 that any indirect impost, duty, or excise tax had been legally assessed as owed, or that a statutory liability for tax imposed by Title 26 had been lawfully determined to exist under Sections 1461 or 3403, which of course are the only two code sections that make any party liable for tax in Title 26, with 1461 making withholding agents liable for what they collected from foreign persons, and 3403 making employers liable for what they collected from employees. So there is no liability in the name of the wage earner. and they just make it up. How? Under the Loper-Bright v. Raimondo, 603 U.S. 369, 2024 decision, the regulations for Title 26 CFR Section 1.1-1, that's Part 1, Chapter 1, Section 1, can no longer be used by the plaintiff United States or relied upon by the courts to allege that an enforceable liability for tax is created under Section 1, because the language of the underlying statute does not itself impose a liability for tax. The regulations for a statute can no longer be relied upon to effect an end result, i.e. liability for tax and a prima facie assessment, that is not provided for by the statutes themselves. At trial, no evidenced statutory liability for tax was ever identified or introduced, and without a subscribed prima facie tax return or a statutorily specified liability for tax, it is virtually impossible for the defendant to have been found guilty of evading or defeating any tax. That's under Section 7201, the criminal charge. Legal determinations of the liability for tax and formal assessments of tax for non-filers are not made by testimony under regulations relying on the Chevron doctrine of regulatory deference, nor even by meticulous testimony, but are rather lawfully made only by the identification of a specific statutory liability for tax that applies and by the execution of a subscribed SFR tax return as required by law under Section 6201, 6020B, and 6020B2, assessing the specific amount of liability for tax to be enforced by the court. The absence of a statute specifying liability for tax is not standard, nor is such unspecified and unassessed liability for tax enforceable in the courts, which can only enforce that which is provided by statute. The auditor's testimony relied upon at trial was not the admissible best evidence under the controlling statute of tax owed that was acceptable as the prima facie evidence in court that is good and sufficient for all legal purposes. No proper admissible prima facie best evidence of any tax assessed on a subscribed tax return form appears in the evidentiary record to create the necessary prima facie evidence of an enforceable liability for tax that is needed to be good and sufficient as evidence of tax owed in court as evidence, sufficient to convict the defendant. The Loper-Bright decision overturned and overruled the Chevron doctrine of regulatory deference. That precedential reversal applies to income tax cases and this case because the SFR regulations of the CFR that were utilized and relied upon in this case to allege a liability for tax under Section 1 and a formal assessment of tax under Section 6020B2 improperly went far beyond the actual command of the statutes. The regulations of the CFR can no longer be used to supersede, eliminate, or replace by unauthorized substitution the clear requirements of the controlling applicable statutes, as was done in this case on these two critically important issues. Okay, I think we're going to be coming up on the next commercial break here in a minute. So we're going to come back to issue 9 when that break is over. And this is the Liberty Works Radio Network. Get on over to the libertyworksradionetwork.com website. Get tuned in, get educated, get signed up, become a supporting member, and inform your friends, family, neighbors, and business associates Okay, this is Thomas Frieda on the Liberty Works Radio Network, and let's just get right back into this. What do you say? Now, before we go on with issue 9, I'd like to say one bit about this issue of using regulatory deference to create liability under Section 1, which is the tax imposed. The problem is that Section 1 imposes a tax on taxable income, not any individual person. Whose name is taxable income? There is no liability specified. It says there's a tax imposed on a taxable income of married persons, heads of households, married filing separately, and single filers, individual filers. Where does the government get authority to tax married people or heads of household or married filing separately? Where do they get authority to tax on this basis of being married or single? That's not in the Constitution. That's not in the 50 states. The only places that basis for taxation exists is in the territories and possessions that were taxed by the original Underwood-Simmons Tariff Act of October 3rd, 1913, that laid the income tax as an indirect tax that is collected from foreigners in America and laid on everybody in the territories and possessions. And the indirect tax is paid liability under 1461 of the withholding agents for what they collected from foreigners under 3403, 40 years later, in 1945, and the employer is made liable. So it's all indirect. The only liability is that of the collectors who collected it from other persons who aren't liable. Why? Because it's an indirect tax under Article 1, Section 8. So when the court says it's a direct tax under the 16th Amendment, where's the liability for the tax? Oh, it doesn't exist in statute. So they had to make it up under Section 1, where the regulation for 1.1-1, Part 1, Chapter 1, Section 1, tax imposed, says liability is established. But that goes beyond what the statute did. But they had to do that because there is no direct implementation of the tax in the statutes. There is no direct liability in the name of the wage earner. They made that up under the 16th Amendment, and then they have to make up liability under the regulation. And they got away with it for 40 years under the regulatory deference of Chevron. But it's not there in the statute. It exceeds the authority of Congress, and it invents in regulation this direct tax that was never authorized, doesn't exist, and can't be allowed, according to Moore in the Supreme Court, under the 16th Amendment. The whole thing was a fraud. They invented the fraudulent direct tax under the 16th Amendment, and they invented the fraudulent alleged liability for the tax under the regulatory deference of Chevron that went far beyond and exceeded what the statute did, which was only pose a tax on taxable income, which would take you to Section 63, referencing gross income, which is Section 61, where wages and salaries aren't listed. They got put there by judicial legislation. Oh, look, compensation. Well, salaries and wages are compensation, so all Americans and everything they do is taxable. More constitutional corruption by a crooked judiciary enforcing the liberal progressive philosophy instead of constitutional law, just like they did in Roe v. Wade, Korematsu, affirmative action, Chevron. Do we need to go on? The liberal court's decisions are being rolled back by this court. And the income tax is where it all begins, because that's how they fund everything, and that's where the class legislation that creates the class warfare and the class divisions playing out in the street. So it all starts and ends with the income tax. Okay, now in this case, there was a separate issue concerning interfering with the seizure of property under Title 26, which never happened in this case, because what happened was the court ordered a foreclosure under Title 28. And that corrupt process was interfered with. But it takes a Title 26 seizure to make this statute be applicable. Let's get into this issue 9. No seizure of property occurred under authority of Title 26 statute to support an alleged violation of Section 7212B, count 3 of the indictment, because IRC Section 7403 is not a statute that authorizes a seizure of property, only the filing of a civil action. So that there can be no further confusion about the lack of the statutory applicability of Section 7212B to the defendant and the facts of this case, the statute provides that it is a crime for any person to, quote, rescue or cause to be rescued any property after it shall have been seized under this title. And we then jump right to a cite of the statute, 7212. Where'd it go? Come back here. Okay, 7212 attempts to interfere with administration of internal revenue laws, B, forcible and attempted rescue of seized property. Any person who forcibly rescues or causes to be rescued any property after it shall have been seized under this title, or shall attempt or endeavor to do so, shall, excepting in cases otherwise provided for every such offense, be fined not more than $500, or not more than double the value of the property so rescued, whichever is the greater, or be imprisoned not more than 2 years. Okay, so in order for property to have been seized, quote unquote, under this title, it would have to have been seized under authority of a Title 26 statute. The only seizure statutes that exist in Title 26 are Sections 6331 and 6335, neither of which is applicable nor evidenced in the case record, as there was no evidence introduced of any notice of levy or notice of seizure issued under those statutes of Title 26. 6331 is levy and 6335 is seizure. Those are the only two places where the IRS has a seizure authority to interfere with. A Title 28 court-ordered foreclosure under Title 28 United States Code Sections 2001 and 2002, which did occur in the defendant's civil case, does not constitute a seizure made under authority of the Title 26 statute, 6331, 6335, to which Section 7212 may apply. The district and circuit courts both erred in holding that Section 7403 constitutes a Title 26 seizure statute, as that interpretation appears to be judicial legislation, as the statute only authorizes a civil action to be filed and does not authorize a seizure to be made as a function of filing the authorized civil action. Section 7403 does not authorize a seizure of property to be made. It only authorizes the filing of a civil action, which is not a seizure under Title 26, but rather the mere initiation of a civil legal dispute that must be fully adjudicated before any real property may be controlled. No seizure under Title 26 occurs as a result of simply filing a civil action under authority of Section 7403. The Circuit Court writes on page 8 of its order, "It is clear from the order of foreclosure and judicial sale," they admit it's a foreclosure, "that the property was seized under Section 7403 of Title 26. No, it's not. The order cites Title 28, Sections 2001 and 2002. What the hell is the court looking at? They're just making this stuff up. There's no evidence. It says Title 28, 2001, 2002. It doesn't cite Title 26 as the authority for the order. This man is flat out lying. Okay, let's go on. Which empowers the IRS to seize the property of delinquent taxpayers. No, it doesn't. 74 authorizes the filing of a lawsuit. It's only the court order under Title 28 that authorizes any property to be seized after the lawsuit is adjudicated. This is insane. Suddenly, Title 28 orders or Title 26 seizures? Not under any Title 26 statute. The judges are just making this up. And they're doing this to people all over the country who try to save their property from unconstitutional foreclosure. Okay, but this is simply not true. The court prejudicially attempts to rewrite the statute by judicial legislation and also wrongfully misrepresents the true facts of the record. Section 7403 does not authorize a seizure, only the filing of a civil action. And factually, no federal seizure ever occurred, as it was law enforcement personnel of the state of Utah who actually seized the Cromar home and property. And they are not authorized to act under Title 26 of the United States Code, the Internal Revenue Code, which only authorizes IRS agents to act, not the state. The state can only act under a judge's order under Title 28. A civil action is not a seizure under Title 26. And Section 7212B cannot be invoked or applied to the factual record in this case because no Title 26 seizure was ever made. The opinion that has been wrongfully invoked by the court to rewrite the statute is prohibited judicial legislation. A strict statutory construction. Where'd this go? What happened here? I think it popped up. Oh, where did it go? Okay, let's find it. A strict statutory construction of the language of Section 7403 should control the resolution of this issue. No seizure of the Cromar home and property ever occurred under a Title 26 statute. There was only an order of the district court issued under authority of Title 28, Sections 2001, 2002, to foreclose on the home and property. The circuit court actually admits that the case record shows there was no Title 26 seizure that ever occurred because it writes on page 3 of its order that in May 2019, Gary Chapman, the IRS agent assigned, discovered that Cromar and his wife were still living there. He enlisted the help of law enforcement, Utah state law enforcement, who removed the Cromars from the property on June 25, 2019. And that was the effective seizure conducted by Utah law officials under Title 28 orders, not Title 26. Had nothing to do with it. By the admission by the circuit court that it was the public law enforcement resources of the state of Utah that removed the Cromars and thus factually seized the home and property at that time is proof that there was no Title 26 seizure that occurred in this case sufficient to criminally charge Cromar, the defendant, under 7212B. Only an officer of the U.S. Treasury, the IRS, is authorized to conduct seizures of property under Title 26 law, and not the state of Utah's quote-unquote law enforcement personnel as admitted by the court, citing IRC 7608, 6331, and 6335. And the foreclosure occurred not under authority of any Title 26 statute as required by the charging statute, 7212B, but only after Utah law enforcement authorities occupied the house under the foreclosure orders under Title 28. Chapman used that foreclosure order to persuade the local Utah law enforcement authorities to remove the Cromars, the defendants, from the home and occupy it as a part of the ordered Title 28 foreclosure. Section 7403A provides that the Secretary may direct a civil action to be filed in a district court of the United States. This statute does not authorize a seizure to be made because a civil action is not a seizure, and no seizure may be made before the civil action is fully adjudicated, simply as a result of the civil action being authorized and filed. That's not how it works. It's got to be adjudicated. Okay, I think we're coming up here on the end of the show, so we'll be back next week to finish this up.